power of the purse and the rule of law. I want to welcome our witnesses here with us today. This morning, we will be hearing from Professor Josh Chaffetz, a professor of law at Cornell Law School and visiting professor at the University of Texas at Austin School of Law. Professor Eloise Pasakoff, Associate Dean and Agnes N. Williams Research Professor at Georgetown Law. Mr. Thomas Armstrong, General Counsel of the U.S. Government Accountability Office, and Dr. Philip Joyce, Professor of Public Policy and Senior Associate Dean at the University of Maryland School of Public Policy. Welcome to all of you. I now yield myself 5 minutes for an opening statement. In Federalist 51, James Madison said that if we were governed by angels, quote, neither external nor internal controls on government would be necessary. Since that is not the case, our founders purposefully embedded a structure of checks and balances into our Constitution to ensure a separation of powers. After fighting a war to rid themselves of a king, the core goal of our Constitution was to divide powers between the branches in order to prevent one branch from gaining dominance and creating a new monarchy. The founders knew that money and who controls it is fundamentally important in a democratic government. They were adamant that Congress control the power of the purse since it can act as a critical check on the president, and because of the House's biannual elections for members, it is the branch most accountable to the people. Congress has carried out this constitutional responsibility to control spending by enacting foundational laws to prevent the executive branch from misspending, laws like the Anti-Deficiency Act and the Impoundment Control Act. But despite Congress's commitment to fulfilling its role, its ability to follow through and conduct oversight of executive spending has been increasingly challenged. Over time, as presidents and agencies have sought to claim more control over spending, they have circumvented the law, ignored the law, and even broken the law, often without repercussions. This threat to the American experiment transcends presidents, parties, or politics. And if defending our institution and the basic premise of our democracy is not reason enough to strengthen our laws, then I would point to the hundreds of millions of people impacted by executive misspending and overreach, the American people. The erosion of our nation's separation of powers poses tangible and destructive impacts for constituents, states, and localities, and the operation of government. Our communities count on the funds we appropriate. Whether it's disaster relief, infrastructure investments, improving our military bases and housing, or strengthening our education and healthcare systems, the American people need to know that when their representatives in Congress pass an appropriations bill and it is signed into law, a structure is in place to ensure that that money gets to the people who need it. That's why the growing lack of transparency about how the executive branch uses non-public apportionments to exert control over agency spending is a major problem. Too often, this leaves the American people and our allies abroad wondering whether, when, and how they will get the support they need, and were promised by Congress. To help protect and enforce its spending decisions, Congress established the General Accountability Office, a nonpartisan legislative office charged with investigating and reporting on violations of budget and appropriations laws. Since its inception, GAO has uncovered numerous instances of executive misspending and impoundment. But even this nonpartisan agency has faced executive stonewalling, underscoring the need for stronger laws that demand compliance. For Congress to remain a co-equal branch of government and fulfill its constitutional responsibility to control how the people's tax dollars are spent, we must reassert Congress's control over spending and ensure we are the ones holding the purse strings. Increasing transparency and accountability will enable Congress to provide the oversight of the executive branch that our founders intended. We're holding this hearing at a time when there is a growing interest in strengthening our constitutional checks and balances. But our nation's separation of powers did not break down overnight. Decades of presidents and federal agencies testing the limits of their executive powers, a changing world that requires quick government action and access to resources, and an increasingly divided Congress more focused on what divides us than what can bring us together, have all exacerbated this clear and present threat to our democracy. But recent and high-profile executive abuses of budget and appropriations laws, including withholding foreign aid, diverting domestic disaster relief, and reprogramming defense funds, have brought Congress's power of the purse into the spotlight and as a result, the American people are demanding action. Today, we will have the opportunity to explore reforms that will help our government better serve the people and operate more like the democracy our founders envisioned. I look forward to what our expert witnesses have to say. And now you have 5 minutes to the ranking member.
I thank the chairman for this hearing, and thank you to today's witnesses for being here to discuss what I consider to be a very important topic. One of the most significant responsibilities afforded to Congress is the power of the purse, clearly stated in our Constitution. Our nation's founding document makes clear that budgeting is not a secondary part of governance, but fundamental to it. There's no escaping the fact that a breakdown in the budget process has exacerbated our dire fiscal situation and the ensuing policy challenges. This committee has felt this dysfunction firsthand. Democrats did not produce a budget resolution last year, and they will not do a budget resolution this year. American families and businesses budget every day. They set budgets for the day, the month, the week, and the year. And my guess is families across America are reevaluating those budgets based on the current COVID-19 situation. Yet here in the People's House, at the House Budget Committee, we won't do a budget. And while my Democrat colleagues on this committee continually attempt to justify the inaction, some of their colleagues seem to recognize the problem at hand. In fact, just this week, the Blue Dog Coalition submitted a letter to Chairman Yarmuth calling on the Budget Committee to produce a budget resolution. They recognize the serious fiscal situation we face and how a budget resolution is the critical tool that can establish the appropriate framework for the entire federal government. The inability to complete the most basic part of the congressional budget process is telling of a much larger problem. Whether you're a Republican or Democrat, it makes no difference. There's no denying that both chambers have relinquished power and failed to adhere to the budget process prescribed by law. Congress has not followed regular order, that is, adopting a budget resolution conference report and separate annual appropriations bills before the start of the fiscal year since 1995. That's nearly 25 years of dysfunction, 25 years of a diminished role in policymaking authority. And let me just add, it creates what is, I call, a new normal for new members of Congress to think that this is a normal way of doing business. While this is a concern of mine and one that needs to be addressed by Congress, there's a much larger issue here. One of the greatest problems we face is the fact that we have surrendered our authority to unchecked mandatory spending. A majority of federal spending is currently running on autopilot without limit or approval. It's exactly the opposite of what our Constitution prescribes. We need to reclaim our authority and bring credibility back to the budget and appropriations process. Our budget process was written in the 1970s. It does not align with the dynamics of the modern Congress. The Joint Select Committee on Budget and Appropriations Process Reform, of which I served as co-chair, examined this very issue during the 115th Congress. We ultimately produced a bipartisan, bicameral package of reforms, one supported by my colleague, Chairman Yarmuth. Unfortunately, we were unable to achieve the required supermajority to affirmatively report the legislation out of committee. Although the outcome wasn't what I had hoped, I remain committed to enacting comprehensive reform that improves our budget and appropriations process. This should be a bipartisan priority and one that includes collaboration by both parties and both chambers. In 2019, Senate Budget Committee Chairman Enzi was successful in reporting a bipartisan and comprehensive budget process reform out of his committee. I applaud Chairman Enzi, all of the committee Republicans, and Democrat Senators Whitehouse, Kane, Van Hollen, and Warner for putting aside partisan politics and producing much-needed legislation. We in the House must continue building on the bipartisan efforts of the Senate and the Joint Select Committee. It is my hope that today's hearing provides insight on ways to address the dysfunction in our budget and appropriations process. It's not only important to the effectiveness of Congress, but also to the country's long-term fiscal health. With that, I yield back the balance of my time.
Thank you for your opening statement. In the interest of time, if other members have opening statements, you may submit those statements in writing for the record. Once again, I would like to thank our witnesses for being here this morning. The committee has received your written statements, and they will be made part of the formal hearing record. Each of you will have 5 minutes to give your oral remarks. Professor Chaffetz, you may begin when you're ready.
Chairman Yarmuth, Ranking Member Womack, and members of the committee, thank you very much for the opportunity to testify today regarding the scope and implications of the congressional power of the purse. The power of the purse is one of the most potent tools in the congressional toolbox. Not only does the Constitution give Congress, and preeminently this House, the lion's share of power over matters of taxing and spending, but that control over budgetary matters also gives Congress significant latitude when bargaining with the executive branch over collateral policy matters. This was a hard-won lesson for the generation that drafted and ratified the Constitution. They were intimately familiar with 17th century conflict between the English Parliament and the Stuart Crown, much of which centered around who would have the power to tax and spend money. After the Glorious Revolution, in which a Stuart monarch was deposed for the second time in less than 50 years, Parliament ensured that the Crown would thereafter be almost wholly dependent on the legislature for funds. And that was one of the most significant steps in the democratization of the English Constitution. Well, colonial American assemblies, who were, after all, at the time, English subjects, in the 18th century, knew this history intimately, and they looked to it for resources in their battle with royal governors and royal judges. Zeroing out executive and judicial salaries, and even refusing to pay rent on the royal governor's house, were among the Assembly's favorite tools of resistance to royal authority. Indeed, the fact that the Crown took to paying colonial judges' salaries out of imperial funds so as to diminish the Assembly's power of the purse was one of the complaints memorialized in the Declaration of Independence. That is to say, one of the justifications for the American Revolution that the colonists offered was that the Crown was paying its own judges. Small wonder, then, that in the years after independence, both the Republican state constitutions and the new federal constitution drafted in 1787 ensured that the power of the purse remained firmly lodged in the legislature, and in particular in the house of the legislature closest to the people. Indeed, the fact that Congress held the purse strings was one of the most common Federalist rejoinders to anti-Federalist fears of a monarchical presidency. That is to say, it was one of the most important talking points in favor of the Constitution as the sort of fledgling Americans were debating whether or not to adopt this new instrument of governance. Subsequent developments, ranging from the insistence on annual appropriations to the creation of the Treasury in 1789, to the creation of the Standing House Ways and Means Committee in 1795, to the Miscellaneous Receipts Statute and the Anti-Deficiency Act in the 19th century, all involved efforts by Congress to preserve and defend the leverage that the power of the purse gives it in interbranch negotiations. Congress gave away some of that power in a nod to the growth of the administrative state in the 1921 Budget Act, but half a century of experience convinced it to take a good bit of it back with the 1974 Budget and Impoundment Control Act. In short, Congress has repeatedly reacted against attempts to encroach on its power of the purse. And it may well be time for the next episode of congressional reassertion in this sphere. In particular, let me briefly mention 6 ways which, in my view, Congress's power of the purse could be strengthened. And each of these are more fully elaborated in the written testimony I've submitted, as is the historical development that I've just outlined. First, greater use should be made of zeroing out some item or salary as a way of combating executive overreach, and especially as a way of enforcing contempt of Congress citations. If the South Carolina colonial legislature could refuse to pay the rent on the royal governor's house, then Congress can refuse to pay the salary of a contumacious executive official. Second, appropriations bills should be drafted so as to make clear that riders are not severable from appropriations. If OLC wants to declare a rider unconstitutional, the executive should have to sacrifice the underlying spending. Moreover, the loss of the entire appropriation is more likely to create a justiciable case or controversy than the loss of the rider alone, and so non-severability may be a way in which Congress can enlist the courts as allies in the battle over budgetary control. Third, criminal penalties should be added to the Impoundment Control Act, just as they already exist in the Anti-Deficiency Act. Illegal impoundments are serious matters, and the code should reflect that. Fourth, the Anti-Deficiency Act itself should be tightened to prevent executive gamesmanship around the essential, non-essential personnel distinction during a lapse in appropriations. Fifth, both houses of Congress should engage in significant capacity building, bulking up the number and pay of member and committee staff, as well as the staff at nonpartisan institutions like GAO, CBO, and CRS. It's impossible to check the executive without the capacity to adequately monitor the executive. And I would add that the work done by the Modernization Committee, and in particular the resolution passed yesterday, is a significant step in this direction. Finally, I agree with the ranking member that Congress should seek to return to the regular orthodox annual budget process laid out in the 1921 and 1974 Acts. That process was built to harness the expertise on both this committee and the Appropriations Committee in the service of granular congressional control over spending. The turn to continuing resolutions and omnibus bills has diminished ongoing congressional control over budgetary matters. The power of the purse is one of the most significant congressional tools that the Constitution gives to Congress, and Congress should ensure that it's using it to its full potential. Thank you very much.
Thank you for your testimony, and I recognize Professor Pasikoff for 5 minutes.
Chairman Yarmouth, Ranking Member Womack, and members of the committee, thank you for the invitation to testify today. I'd like to make 3 points this morning. First, presidents have many tools to shape spending after the appropriations process in Congress has come to an end. And in general, these tools play a useful role in ensuring efficient spending of taxpayer dollars within the bounds of the law. Second, like any tool of implementation, these tools can be misused, and they recently have been. Third, there are a number of opportunities for Congress to cabin the misuse of these tools while still recognizing their value in the ordinary case. And in the rest of my time, I'll illustrate these points by walking through recent experiences with 3 key presidential budget tools. The first tool that I'll discuss is apportionment under the Anti-Deficiency Act. This is the authority to specify by time period and by project how agencies may spend their appropriations. The purpose of apportionment is effective funds management. It's not an independent source of executive policy development. But the current administration seems to be developing an expansive view of apportionment as a tool of presidential control. The most prominent example of this occurred last summer when OMB placed holds on some foreign aid funding, including to Ukraine. Now, these apportionments became central to the impeachment inquiry, but that's a completely different issue from the one that concerns us today, which is the administration's broad view of its apportionment power. In defending these apportionments, OMB attempted to place the president's apportionment authority in the context of his constitutional duty to take care that the laws be faithfully executed. But as GAO correctly explained, faithful execution of the law does not permit the president to substitute his own policy priorities for those that Congress has enacted into law. So Congress could usefully clarify these limits on apportionment, and it could also require that apportionments be made public rather than letting the executive keep them secret. The second tool I'll discuss is rescission and deferral under the Impoundment Control Act. Congress passed this act to limit presidential attempts to unilaterally withhold funds, sometimes called policy impoundments. Under this act, a president who wants to cancel certain spending must make a rescission proposal to Congress, and Congress must affirmatively pass a rescission bill within 45 session days, or the president must release the funds. And a president who wants to defer certain spending for operational reasons, not for policy reasons, must tell Congress about the delay. Here, too, the administration is engaging in expansive interpretation of presidential authority. On rescission, the OMB has claimed that the act permits the president to unilaterally cancel any spending he wishes if Congress doesn't have time to act on a rescission proposal before the end of the fiscal year. But this isn't right, as GAO has explained. To read the act to allow the administration to cancel spending without congressional approval is to ignore the limits that the law clearly places on presidential efforts to impound funds. The administration's expansive view of deferral is no stronger. It is trying to expand a category that GAO has distinguished from deferral called a programmatic delay. And the administration has essentially argued that something is a programmatic delay whenever the president says it is. It is also argued that executive branch policy decisions can justify a programmatic delay. But again, this just isn't right. OMB's reading would allow the category of programmatic delay, which isn't even mentioned in the Impoundment Control Act, eclipse the controls that Congress put in place in that act. OMB's reading would also mean that the administration is the only one policing itself for compliance with the Impoundment Control Act, which again is not how the rule of law operates. Congress could usefully reject both of these arguments in amendments to the Impoundment Control Act. The last tool I'll discuss is transfer and reprogramming. A transfer moves funds between different appropriations, while a reprogramming changes the allocation of funds within a single appropriation. And here, too, the administration is taking a particularly broad view under these authorities. It's been actively using these tools not just through the emergency declaration and not just in building the wall, but more generally in other areas of domestic and foreign policy as well. The lack of transparency in these actions, too, makes it difficult to monitor and hold the executive branch accountable. So Congress could, again, usefully place more specific restrictions on transfer and reprogramming, and could also require more transparency around the use of these tools. Thank you for your time and your attention to these important issues.
Thank you very much. Now recognize Mr. Armstrong for 5 minutes.
Good morning. Thank you, Mr. Chairman, Ranking Member Womack, and members of the committee for this opportunity to speak with you about the work we do at GAO. Since GAO was established in 1921, we've prepared audits, investigations, and legal decisions for the Congress. What I want to focus on this morning is the legal work we do, the legal decisions that we issue. We do a number of things in this area, and it's all designed to support your constitutional prerogatives of the purse. We issue decisions to members of Congress and committees of Congress. We issue decisions to executive branch officials. In fact, some executive branch officials have a statutory right to a decision from GAO, and that's very important because it's through our decisions that we establish standards to ensure compliance with the Appropriations Acts and with fiscal statutes. We are kind of on the front line for the Congress. We also have responsibilities under the Anti-Deficiency Act. For example, we maintain the official repository of reports by executive agencies of ADA violations, and we report annually to the Congress on what we have found in the previous fiscal year. And shortly, you'll be getting a report from us about fiscal year 2019. As I think everybody knows by now, we have certain very significant responsibilities under the Impoundment Control Act. Another thing that we do, and this is where we help the Congress make sure that things are running as they should be in the executive branch, is we have something that we call the Red Book. It's the Principles of Federal Appropriations Law. It's a multi-volume treatise on appropriations law. It's called the Red Book because in hardcover it's red, and attorneys are kind of clever like that. So it's the Red Book. That is a compendium of 99 years of case law based on 99 years of experience and expertise. That is regularly referred to throughout the executive branch, and it's referred to by the federal judiciary. There are some things that have happened in the past few years that I think compel legislative action on your part that would strengthen our role, because if you strengthen our role, you're really strengthening your oversight of executive spending activity, and we can provide you information, legal views, legal conclusions that I think are so very important to you as you work through the appropriations process and you make choices. I think it's important to you as you carry out your own oversight of executive activity. Mr. Yarmouth, you and Mr. Womack may remember that a little over a year ago, you asked us for an opinion whether the Impoundment Control Act allowed a president to propose a rescission during the last 45 days of a fiscal year when the money that would be proposed for rescission would expire by operation of law before the end of that 45-day period. We said no, that the administration did not have the authority to do that. And that's something where you might want to make clear in the Impoundment Control Act. We do have recent experience where the current makeup of the Office of Management and Budget has advised executive general counsels that they don't need to listen to GAO's decisions and opinions. So to ensure this, you can put it in law. In that regard, something else that I would mention is that OMB regularly gives instructions annually to federal agencies on the budget process, and specifically on the Anti-Deficiency Act. Until last summer, OMB for decades had instructed agencies, if GAO concludes that you violated the Anti-Deficiency Act, you need to report that violation. You can and should report your disagreement with the violation if you disagree, but you should report it. Last summer, OMB revised that instruction and said, you only have to report a violation if we, OMB, and you, the agency, agree with GAO. So we sent a letter to executive general counsels and said, if we conclude that there's a violation of the Anti-Deficiency Act and you don't report it, we are reporting it. I think that that's information that the Congress should have as the Congress oversees executive spending and as the Congress makes its choices in the appropriations process. And if I could take just one more minute, one other point I would make is some years ago, the Office of Legal Counsel over at the Department of Justice basically told agencies, if you violate a spending restriction, and that spending restriction was enacted by Congress into permanent law as opposed to an Appropriations Act, you don't need to report that violation to Congress. In effect, it's a rather anomalous policy of Congress gets information depending on the legislative vehicle Congress has chosen. If it's in an Appropriations Act, the Office of Legal Counsel says you have to report it. If the restriction's not in an Appropriations Act, you don't have to report it. And again, when we uncover things like that, we do report it. I'm going to read a quote, because when I think about these legislative ideas we have, and when I think about the topic of this hearing, I am reminded, again, James Madison in the Federalist Papers in 1788, when he was talking about the power of the purse and that it should be housed in the legislature, he made the point that allowing it in the legislature will help reduce, quote, all the overgrown prerogatives of the other branches of government. I think that's the power of the purse. Thank you very much, and I'm sorry for going over time.
All right. Thank you for your testimony. Dr. Joyce, you're recognized for 5 minutes.
Thank you very much, Chairman Yarmouth, Ranking Member Womack, members of the Budget Committee. I appreciate you inviting me to share my views on the role of Congress in the budget process. I believe a strong congressional budget presence is crucial to the health of our democracy, and that ineffective congressional budgeting invariably strengthens the executive and weakens the Congress. In my testimony, I'm going to discuss how we got to this place, in addition to articulating some steps that are talked about in more detail in my written testimony that might be taken to shift the balance of power to a place where the Congress can be on a more consistently equal footing with the executive. I would start by saying that I testified before this committee in May of 2016 in a very similar hearing, and I try to avoid quoting myself, but I'm going to. I read in that testimony a sentence that said, "It might be particularly fruitful to talk about this now, since we don't know which party will occupy the White House in January of 2017. And all I had to do was change the date to 2021, but I think the sentiment still applies, which is that you may be able to think about the protection of congressional prerogatives, as I think you should, relatively unconstrained by knowledge of who would control the presidency and the Congress. It's important, I think, to start by reiterating the reason that the 1974 Act gave us budget committees and the budget resolution and CBO, and it's because they were viewed as essential to the Congress reclaiming the power that had shifted too much to the president. And some parts of the law have worked well. I think CBO has given the Congress the analytical power to challenge the executive, and reconciliation has proved a very useful tool for the Congress to cut the deficit when it wants to. However, the budget resolution itself has only been passed about half the time in the last 2 decades, after being passed every year for the first 2 decades after the 1974 Budget Act. This suggests the possibility that the problem is not at least wholly procedural. In fact, in 2011, I testified before this committee with its former chairman, Jim Nussel, and he suggested to the committee that, quote, "Before you search for new budget procedures to fix the current process, actually give the current process a try." I agree, and I think that the Congress basically had it right in 1974 when it created these committees and CBO and the budget resolution. In my testimony, I do suggest several changes in either law or practice that could assist the Congress in reasserting its congressional or its constitutional role in budgeting. First, I would change the budget committees into committees on national priorities to include the chairs and ranking members of the appropriations, tax writing committees, and also other major authorizing committees. I think this would lead to the budget resolution being taken more seriously. Second, I would make the resolution itself stronger by thinking more comprehensively about how all the resources devoted to particular policy aims would be used and how they're traded off against each other, rather than focusing on distinctions which are largely driven by committee jurisdiction between discretionary spending, mandatory spending, and tax expenditures. Third, I do think it's important for the Congress to articulate a path for the budget on a routine basis. This doesn't necessarily mean passing a budget resolution every year. I'm sort of agnostic about biennial budget resolutions versus annual budget resolutions, but as a matter of routine, I think having to confront the future path of the budget and deciding whether to use the tools available to you, primarily reconciliation, is a very important thing to do. Fourth, I think the abysmal record of the Congress on appropriations contributes to the general loss of public regard for the Congress. It's put you in a weakened position relative to the President and is a completely self-inflicted wound, given that in only 3 of the last 44 years have all the appropriations been passed and signed into law before the beginning of the fiscal year. Fifth, I think Congress should take its oversight role seriously by attempting to figure out how well programs and policies are working and how they might be changed in order to be more effective. Sixth, I think that Congress should support and defend the analytical institutions, especially CBO and GAO, that assisted in performing its constitutional responsibilities. And finally, I think that Congress should stand up for itself in the appropriations process by asserting its prerogatives to decide on the details of spending, ensuring in particular that the provisions of the Impoundment Control Act are followed. In conclusion, Article 1 of the Constitution comes first for a reason, and the Congress is called the first branch because of the desire of the founders that policies and laws be initiated by the representatives of the people. The budget process is the central means of deciding who will pay for government and what government will do. Power abhors a vacuum, however, and if the Congress doesn't reassert its authority through law and action, it will inevitably lead to the further transfer of power to the executive. Thank you very much.
I thank the gentleman. We will now begin our question and answer session, and we're going to depart from our customary pattern, and I'm going to recognize the ranking member, Mr. Womack, for 10 minutes.
I thank the chairman for giving me this opportunity early in the hearing because I do have a couple of other hearings that I have to depart for, and I appreciate, again, the testimony and, quite frankly, the education that we've received from these experts that are seated before us. Dr. Joyce, question for you. We all know that our democratic government is based on a system of checks and balances, and as I mentioned in the hearing we had yesterday with DOD Deputy Secretary Norquist, I have some serious concerns about the executive branch's recent decision to substitute its judgment on key defense funding decisions that were made by the Congress of the United States. So regarding discretionary spending that is provided by Congress in the appropriations process, what are the checks and balances that we have over the executive branch to ensure the administration implements the bills that fund the government in accordance with the intent of Congress?
Well, partly I think what you have to do is think about exactly how much detail and direction you want to provide in law in those appropriation bills. I mean, often where the gray area comes in might be where there's guidance that's in report language or guidance that's in, you know, something that's said on the floor, but it's not necessarily in the bill itself. So I think you, in some sense, have no choice in that kind of situation but to try to make the law more strict in terms of what you're permitting and not permitting to happen.
You've done extensive work in this area, and as you indicated in your opening, you testified before this committee in 2016 about this broken budget process. With that said, it's extremely frustrating to me and probably to you that we've not been successful in fixing this process over time. We gave it a good try in 2018, as was mentioned in my opening. The chairman was with me. The guy that sits here to my right was with me during this process. We got very close to the finish line, but fell just a little bit short. And now Congress continues to rely on a harmful practice such as CRs, omnibuses, and budget deemers to fund the federal government. So in your opinion, why have we failed? And let me just add this. When the vote was taken, the threshold was a supermajority. We had to have 5 and 5 out of the 16-member committee, 4 Republicans each, Republican, Democrat, House, and Senate. 4 of my Democrat colleagues voted present on the final vote. Why have we failed?
I think in part, I think it's always hard to change the status quo because the people who are present at any given point in time might feel like they're getting some benefit from the status quo. I think also, you know, there's a serious question in my mind, you know, given the overall fiscal situation we're in, how much budget process changes themselves can help us get out of the, you know, $23 trillion worth of debt. The Congress doesn't tend to, the budget process is not good at forcing the Congress to do things that it does not want to do. And I think the places where the budget process could be changed and where I think some of the sort of fruitful kinds of process changes that you had considered are places where it would give the Congress more information and it would help the Congress to better stay on its on the schedule that's it's established for itself. I think people confuse having the budget process get us out of the fiscal mess with having the budget process sort of helping the Congress to be able to have a more effective means of making those decisions. And maybe it's difficult for people to sort of separate those two. I thought that your committee did a very good job of doing that, actually, of keeping the procedural fixes where they ought to be. I do think that in that particular case, the rules that were set up in advance, which I understand why they were, but they required such a supermajority that the hurdle was very high in getting something out of that committee.
That may have been intentional
Right.
on their part. I don't know, but we got very close. Professor, I have a quick question for you. In my opinion, and thank you for the history lesson, that was very instructive to me. And I need to read more of that. To me, it is grossly antithetical for, instead of doing a budget resolution and doing what we call, all of us call regular order, that we would kick the decision to 4 people, basically, the leaders of the House and the Senate, to basically decide what those numbers that our appropriators are going to write to, and have nothing to do, by the way, with mandatory spending. That's a whole other subject. But for 4 people to have to come to some agreement on what the appropriators' 302As should look like, do you agree with that?
I do agree with that. One of the things that the rise of continuing resolutions and omnibus bills certainly does is shift control from committees generally, and especially this committee, to leadership. You asked Dr. Joyce why previous efforts had failed. I would point you there, right? Leadership has, cameral leadership has relatively little incentive to try to decentralize power to committees when it can sort of maintain that power in itself. And so you have a situation where leadership of both parties is much more invested in something like the continuing resolution omnibus way of going about things than in the regular order.
Any of you that followed the Joint Select Committee knows that we struggled, had a lot of discussion about and struggled with the old carrots and sticks idea. Personally, I think that there have to be some consequences for the failure to do your job. In the private sector, failing to do your job means you probably don't have a job. But up here, it's a little bit different. You talked in your recap of history that there were consequences where there was the withholding of either rent or pay or something, some benefit that would accrue to the people that are violating the terms. Is it going to be necessary for us to have some serious consequences ultimately for the Congress not to do its job?
I think it's important for this committee to sort of decide how much of that power it really wants to wield and how much it wants to cede to leadership. There are consequences for sort of Congress as an institution, right, in terms of the sacrifice of its power to the executive. I think equally there should be consequences for the executive. A lot of what I talked about in the sort of historical recap was situations in which the executive branch tried to seize appropriations power or tried to wield appropriations power on its own without the legislature, and the ways that various legislatures have pushed back on that. And I think Professor Pasikoff sort of pointed us to a lot of ways that that's happening today as well. So in thinking about what there should be consequences for, I would point first to consequences for sort of executive branch usurpation. And maybe one way that Congress can go about implementing those consequences is through revamping its own procedures, and perhaps one of those would be a return to regular order.
I thank the panel for your testimony here today. I wish I could sit through all of it. I'll get a report back for what else transpires here today. And again, Mr. Chairman, I want to thank you for your hard work on the Joint Select Committee. I thought we did really, really good stuff and maybe have a blueprint for how things can go forward. But this is, in my serious opinion, one of the most pressing issues facing the Congress of the United States, and that's to get back to some regular order on budgets and appropriations. Because while there may not be consequences for us failing to do our jobs, there are consequences for this country eventually, and that is yet to be determined. And I yield back.
Gentleman yields back. I now recognize the Vice Chairman of the committee, the gentleman from Massachusetts, Mr. Moulton, for 5 minutes.
Thank you, Mr. Chairman. And as the Vice Chairman of the committee, which sounds like a much bigger deal than it actually is, I would like to thank both the ranking member and the chairman for their work on that Joint Select Committee. And I do wish they had been successful, and it's an effort that we should try to do again. Thank you all for joining us here today. You know, I think you may not realize it, but you're actually very fortunate to be here today in the hot seats, because I can't remember a time when there's been more bipartisan consensus on this committee and bipartisan concern. And, you know, I think that we'd be a better Congress if that happened more often, because in the midst of a very difficult, divisive time in politics here in Washington, we can't forget why we're here. And the solemn oath that each of us swore, not to the Speaker of the House or the President of the United States, not to this party or that party, but to the Constitution that we all hold dear. We don't spend enough time thinking about that oath and understanding the Constitution and the laws, those wise restraints that make us free, that support it. Certainly one issue of bipartisan concern here is the diminishing role of Congress and our diminishing willingness to exercise our authority when it comes to oversight of the executive. At the beginning of the year, the Government Accountability Office determined that the administration violated the law when it withheld military assistance from Ukraine. Mr. Armstrong, I have a feeling you played a role in making that determination. Can you share briefly how you came to that conclusion?
You know, Mr. Moulton, that was really a fairly straightforward legal analysis. The Impoundment Control Act is the only authority that a president has to withhold funds from obligation. The president doesn't have any constitutional authority to withhold, doesn't have any inherent authority to withhold. And the Impoundment Control Act permits a withholding for policy reasons only if the president submits a rescission proposal and waits 45 days. And if Congress does not act to rescind during that 45-day period, the president must release the money. What we found was that this administration withheld funds from obligation for almost 2 months. And when we asked the Office of Management and Budget the reason for it, OMB told us that it was to ensure the money was going to be spent consistent with the President's policy considerations. There is no authority in the Impoundment Control Act to withhold for policy reasons. It's really clear. And so there was not that difficult a legal decision to come to. The difficulty we had and the time we had was developing the information we needed to establish the facts and to analyze those facts, because we apply the law to facts and we go where the law takes us.
So, I mean, hearing that a president might withhold money for policy reasons, I imagine sounds to many like a reasonable thing to do. It doesn't seem totally out of the ordinary, but the problem is that, as you say, it's against the law. Is that safe to say?
Yeah, that's right, yeah.
And is there anyone on the panel who would disagree with that? Professor Shavitz, you're the constitutional historian, or at least one of them here today. What might have concerned anti-federalists like Jefferson and Madison about power shifting more and more to the executive under modern presidents, both Democrat and Republican? And in this particular example, how would their interpretation of the necessary and proper clause of the Constitution inform these concerns?
Well, just to be clear, when we're talking about the Anti-Federalists, we're talking sort of earlier, a little bit earlier time period. We're talking about the people who actually opposed ratification of the Constitution, so people like Patrick Henry and Luther Martin. And their main concern when they looked at the structure of the presidency was that it looked a lot like the British Crown. You know, you've got this person, and admittedly elected only for a term of years, but who has control over the military, who has a role in the legislative process with the veto. They were concerned about a sort of overbearing presidency. And the response they kept getting from people like Madison and Hamilton was, you don't need to worry as much about the president because Congress will always have the power of the purse. And in particular, there's a provision in Article 1 that says no appropriations for the Army can last for more than 2 years. So they said, look, every new Congress will have the opportunity to defund the military if we see the president using it in an oppressive way. So the idea that the power of the purse was the central reason that you could trust the new Constitution against this fear that the president would become a monarch. That was the sort of big concern there.
Thank you very much. Thanks, Chairman.
Gentleman's time has expired. Now recognize the gentleman from Ohio, Mr. Johnson, for 5 minutes.
Well, thank you, Mr. Chairman. I'd like to echo what the ranking member said earlier. Your work on that, the bicameral budget reform group. I wish we had actually produced some things. I have tremendous respect for you and the work that you do, but I'm a little bit confused, you know, because today, this hearing is called Protecting Congress's Power of the Purse and the Rule of Law, but I wish instead it was titled Exercising Congress's Power of the Purse and Complying with the Law, because we're doing neither. We're not here to mark up a budget because, Mr. Chairman, you haven't been able to bring your colleagues around to produce a budget. In fact, this is the second year in a row, and I might remind that the last time that my colleagues had control of the House, for 4 years, they didn't do a budget. There's a philosophy on that side of the aisle that says budgeting is not important. It's the chief responsibility of this committee to write a budget resolution. Instead, over the last year, we've convene hearings to talk about things like Medicare for All, the Green New Deal, and the need for comprehensive immigration reform. But we have not come together to do what we're sent here to do, to pass a budget. To put it simply, we have not done what the American people sent us here to do and what the law requires us to do. The failure of this committee to write a budget resolution is a failure of our constitutional duty. In other countries, the refusal or inability to pass a budget leads to motions of no confidence, resignations of prime ministers, and snap elections, but not here, not in Congress. Thank God it doesn't work that way, or we'd all be out on our ears. My colleagues are well aware that there are no consequences for inaction, even though the Budget Act establishes the various steps and deadlines of the congressional budget process. Instead, Congress relies on continuing resolutions and omnibus appropriations to fund our federal government. Just yesterday, the Deputy Secretary of Defense testified before this committee and gave many examples of how CRs create uncertainty for our men and women in uniform and weaken our military readiness. And yet, Congress will likely rely on another CR this year. I'd like one good reason why we should rely on CRs and why we're not passing a budget. I've asked that question, but I have not gotten an answer. You can't reconcile that because there is no good reason why Congress is failing to pass a budget. I respectfully remind my colleagues, my Democrat colleagues, that by failing to write a budget resolution for fiscal year 2020, they have essentially violated the Budget Control Act, the Budget Act. So if this committee wants to have a meaningful discussion on Congress's power of the purse and the rule of law, then we should start by following the law. Produce a budget. Let's have a markup. Or at the very least, let's convene a hearing to discuss the need for bipartisan, bicameral budget process reform. This is the House Budget Committee, so let's do what the law requires us to do and what the American people expect us to do. Okay, Dr. Joyce, the last time Congress successfully observed the process, adopted a budget resolution and a conference report, followed by separate appropriations bills before the beginning of the subsequent fiscal year, was in 1995. How effective do you think the Budget Act has been in enhancing Congress's control over the budget?
I think in practice it hasn't been very effective. It certainly hasn't been very effective since that point. When it was most effective was, I would say, in the first half of the 1990s, when reconciliation was used to actually try to get a handle on the large fiscal problems that were facing the country. But without using those tools, I think the Budget Act cannot be very effective.
Do you have any thoughts about how Congress can improve the current congressional budget process?
I think most of the issues around the failure of congressional budgeting do not have to do with the process.
It has to do with complying
They have
with
to
the
do with
process.
the operation of the process, not what the process says in law.
Okay, what elements of the Budget Act do you believe should be retained as we move through potential budget process reform?
Well, I mean, I do think that the role of CBO is very important. I think CBO has empowered the Congress in a way that it was not empowered prior to that point. And I think the budget resolution, when used, and reconciliation are powerful tools. As I suggested in my testimony, I would actually strengthen both the budget resolution and the budget committees.
Okay, thank you, and Mr. Chairman, I yield back.
Yep, gentleman's time has expired. Now recognize the gentlewoman from Illinois, Ms. Schakowsky, for 5 minutes.
Thank you, Mr. Chairman. Mr. Armstrong, just let me say this, I'm in my 22nd year in Congress and have relied heavily on the GAO all that time in getting the kind of nonpartisan and accurate and helpful information in so many different ways. And I just want to put that on the record, how much it is appreciated.
Thank you, ma'am. I will pass that on to the controller.
Thank you. And I know that even the Supreme Court and other federal courts have cited decisions of the GAO. I wonder, you referred to some, but I wonder if you could summarize the ways in which Congress might help, or that we may even pass some laws that would make your work more effective. I know that you cited a couple of things, but if you could give us the guidance right now in summary, I would really appreciate that.
Yeah, we can. We have a pretty long wish list, so to speak, that we can sit down with staff and walk through that. Among the things that I consider to be higher priority would be ensuring legislatively no impoundments during the final 45 days of a fiscal year, requiring that agencies report Anti-Deficiency Act violations even if they disagree with GAO's findings, making clear that a violation of a spending restriction enacted in permanent law rather than an Appropriations Act does need to be reported to Congress. And something that may be seemingly mundane is requiring agencies to be responsive to GAO. As part of our regular process, when we open up a case, one of the first things we do is we send a letter to the general counsel of the agency whose appropriation has been questioned. And sometimes it takes months to get responses to those letters. A fairly notorious case was last year in September, we issued a decision on Department of Interior activities during the fiscal 2019 lapse in appropriations. We ended up issuing the decision without a response from Interior. We sent a letter to the solicitor of the department, and 3 months later, they still had not replied. Curiously, the day after we issued the decision, we got their reply. We issued the decision anyway because we were confident with the information we had been able to develop publicly and information that we were able to develop from members' offices too, correspondence that Interior had with members.
Ostensibly, are they required to answer in a timely way, or is there just this lack of insistence?
There's no legislation that requires it, but there has been a longstanding practice. I'll tell you, I've been at GAO doing this work for 42 years, and we've never had the problem to this extent. And there are times when an agency will come back to us and say, we need a little bit more time. And we understand that, and we're willing to work with that, so long as they eventually do respond to us. Now, that is something that seems rather mundane, but remember, our role is to provide you the information, legal views, and legal conclusions that you need to exercise your oversight of executive spending activity.
Has that ever prevented you from making a decision because there has not been a response?
No, but it has seriously delayed
Sure.
the issuing of decisions, because when we don't get a response, we try other ways to get the information we need. What we don't have when an agency refuses to respond is we don't have that agency's legal views. And we want to be fair, we are nonpartisan, so I want to know what the other agency thinks. I want to know what how their lawyers defend and explain their actions. That informs our decision.
Of course.
And without a reply from, in this case, the solicitor, we're not so informed. I'll tell you that when we did get their reply the day after we issued the decision, there was nothing in the decision that would have changed our conclusion.
Okay. I've just, my time has just expired, but I appreciate the answer and hope in a bipartisan way we can work with you to make those improvements in the law. Thank you. I yield back.
Well, I'm willing to talk more about it.
Thanks, good. Gentlewoman's time has expired, and now recognize the gentleman from Texas, Mr. Flores, for 5 minutes.
Thank you, Mr. Chairman. I'd also like to thank the panel for joining us today. I think this has been helpful. I could belabor the point about the fact that this committee has not passed a budget, but I think that's been done adequately so far. One of the areas where the federal budget struggles is because Congress continues to appropriate money for programs where the authorization has lapsed. And based on the latest numbers I've seen, it's about $300+ billion a year, which another way to put it, it's 30% of a $1 trillion deficit. So that would be one easy way for Congress to address a substantial part of the deficit. So there are tools that have been talked about to deal with this issue, and I'd like to bounce that off of you moving forward. So I'm going to direct my questions to Mr. Armstrong and to Dr. Joyce. Do you agree that the amount of money we spend on authorized programs is a problem, Mr. Armstrong?
You know, the lack of an authorization removes the oversight committees from the process. And I will say that when Congress enacts an appropriation and there is no authorization, the appropriation does stand as the authorization. So the failure of an authorization is the failure to get the input of the oversight committees.
Correct.
Now, that's Congress's choice. You know, a GAO doesn't have a position on that. As a lawyer, I can tell you that when Congress enacts an appropriation, the President, under the Constitution, is supposed to execute that law, and executing an Appropriations Act is obligating and spending the money. So it doesn't legally need an authorization.
But it's still Congress abdicating its responsibility for oversight,
It
correct?
removes the oversight committees from
Dr.
the
Joyce?
process.
Well, unconstrained by having to be nonpartisan, I will say I do have an opinion, which is that, you know, I think this is a problem, and it's a long-standing problem. I worked at CBO from 1991 to 1996. CBO is required every year to do a report on expiring authorizations and unauthorized appropriations. And as I recall, the number on the domestic discretionary side, the percentage has been consistently about 40%, you know, almost forever. And so, and I agree entirely that what that means is that the Congress is failing to exercise effective oversight. That's one of the things I talked about in my testimony. When I say effective oversight, I mean trying to actually figure out whether programs are working or not. I don't mean just hauling somebody before a committee because, you know, a story appeared on the front page of the Washington Post.
Right. Now, there are a set of tools that have been introduced that would deal with this issue, so I'd like to get the feedback of each of you. Let me run through the tools first and then get your feedback. The first tool would be mandatory sequesters and sunsets for unauthorized programs. Specifically, you'd initially put the unauthorized programs on a pathway to sunset in 3 years, which would be enforced by a reduction in the overall budget authority based on the total value of the unauthorized programs. The second would be to establish a commission that would have 3 tools in its portfolio. One is to establish a full authorization schedule of all discretionary programs and agencies for Congress to use as a tool to keep track of these. Secondly, is to conduct a review of all mandatory spending programs with a view toward the third item, and that is in the event there's an unexpired program that's reauthorized by Congress, then the commission would identify the resources to restore the funding by identifying cuts to mandatory programs to use as budget offsets for that restored funding. So, Dr. Joyce, what do you think about those particular tools to address this issue?
Well, I mean, I haven't thought a lot about sequestration of mandatory spending. I think the idea has merit with respect to discretionary spending.
Well, this would be for the on the discretionary side.
Yeah, on the discretionary side, and I think, you know, anything that you could do that would turn up the heat, you know, which I think this would do, because it would say something bad is going to happen if you don't actually reauthorize the program. In terms of, you know, I've always had mixed feelings about setting up sort of, you know, extra, you know, procedural committees in order to do something that the Congress should be doing itself.
Yeah, I do too.
And so, you know, that's a relatively desperate step, which doesn't mean it might not be necessary. It just means I would rather have the Congress do what it's supposed to do.
And Mr. Armstrong, I'm down to 14 seconds, so what I'll do is ask you to supplementally answer this, or just unless you can give me a yes or no answer, would these tools be helpful?
We'll supply something for the record.
Okay, great, thank you. I yield back the balance of my time.
Gentleman yields back. I now recognize the gentleman from New York, Mr. Morelli, for 5 minutes.
Thank you, Mr. Chairman, and thank you to you and the ranking member for holding this important conversation. My colleague and friend, Mr. Woodall, and I sat through a Rules Committee hearing last week to talk about Article I prerogatives, and so this is very timely that we be talking about it as it relates to the power of the purse. So I appreciate that, and I appreciate the witnesses bringing their historical perspective as well as their legal perspective on this issue. I'm pretty new to this process. This is my first term in the House, and I suffer because my point of reference is state budgeting, where I spent 2 decades in the New York State Legislature, and as my friend Mr. Horsford and I were just talking about, since we both share state legislative backgrounds, this is a much different process. So for me, I want to ask some basic questions. Professor Chavez, did I say that right? Close enough? When the President and the Congress disagree about the legality of an appropriations law, like a funding restriction written into a section of the appropriations law, how does that get resolved?
So for the most part, the Justice Department, through its Office of Legal Counsel, resolves that for the executive branch. The executive branch treats OLC opinions as binding. And then in many cases, that is largely going to be effectively the final word. There's sort of no unless Congress wants to come back and do something about that, in many cases, these will be non-justiciable. They won't work their way into a court. And so OLC's judgment on that will sort of stand as the final word.
So is that like the Red Sox and Yankees dispute a call and the Yankee umpire gets to choose?
Something
Is that
like
a bad
that.
analogy?
No, not bad at all.
Do you have would you suggest a different process or a way to resolve it? Because it does seem to me as though, and not only this Justice Department, but any Justice Department would, I think, be more inclined to agree with the executive. I don't know if that's been the historical trend, but it certainly seems to me that I would expect that to happen. Is there a better way to do that?
You're absolutely right that the Justice Department, OLC, does tend to side with the executive view on that, and they actually see that as in some sense, as their mission, that they try to interpret the law, but with an executive-centered account of the law. One of the things I suggest in my testimony is what we call non-severability clauses, which is to say, if you have an appropriation that comes with a rider, you say that you either take them both or leave them both, right? That you can't take the appropriation and leave the rider. And sort of making that explicit in appropriation statutes would then present a much harder choice to the executive branch, right? For the most part, they want these appropriations. I mean, we've talked about the Impoundment Control Act. Sometimes they don't want the appropriations, but assuming they want the appropriation, now they really have to make a harder choice, and that might sort of force them to make a little bit more honest of a choice. I also think that raises a greater likelihood that you could actually get judicial review of some of these decisions, because if they don't spend the money, then there are potentially private beneficiaries who would have standing, who would have gotten some of that money, who would then have standing to sue and say, why didn't we get the money? And the government will have to say, well, because we determined that the rider was unconstitutional and therefore the appropriation is unconstitutional, and then the court would have the authority to resolve that dispute.
Very good. Professor Pasachoff, did I do justice to them? I'm really killing names this morning, I apologize.
Pasachoff, but again. fine.
Pasachoff. If an agency or OMB violates a budget or appropriations law, what happens and how do we find out about those violations?
So some of it is just happenstance. So sometimes something happens to get disclosed, and then GAO does its work and writes a report about it, and the matters brought to Congress is in the public's attention then. But when things are not disclosed, there's not sort of an automatic source.
There's no systematic way to do it.
There's not an automatic source of knowledge. So one of the things that I write a little bit about in the testimony,
Yeah.
the written testimony that I've talked a little about today, is the importance of transparency and for Congress to claim more tools to force the executive to make transparent some of its spending decisions through, for example, apportionment, and through what it does with reprogramming and transfer.
Yeah, could you talk about that, just a little bit, expand on that? I have, well, I only have about 30 seconds, but if you give some specificity to that.
Sure. So Congress has granted OMB the authority to further specify the appropriations that Congress, passes into law. And when OMB further specifies, those have the force of law that the agencies have to follow, but Congress, those are not public. Congress never sees what the apportionments, final apportionments are.
So your recommendation would be a report back to the Congress
Exactly, that-
delineating or detailing what those apportionments are.
Exactly, that all apportionments be made public.
Very good. Thank you, Mr. Chairman. I yield back. Thank you to the panel.
Gentleman's time has expired. If I may ask the witnesses, I know it's kind of weird when you're talking to the extremities of the dais here, to make sure you speak into the microphone. I think they had a little trouble hearing you, Mr. Javits. I now recognize the gentleman from Oklahoma, Mr. Hearn, for 5 minutes.
Mr. Chairman, thank you. Witnesses, thank you for being here today. I've been in countless meetings and hearings over the last 2 weeks being critical of the president's budget, yet I hear no criticism of this committee not doing its budget. And some would argue, well, it's not the rule of law, but I want to read the responsibility of this committee as on our website. The committee's chief responsibility is to draft an annual concurrent resolution on the budget that provides congressional framework for spending and revenue levels. It goes on to talk about this. So we ought to be critical of this committee. And we ought to be focusing on this committee's lack of performance. I don't blame the chairman. The chairman's a great guy, he really is. I think he wants to do a fantastic job. We got it out of committee last year, but what I do blame is the speaker, the leader of the House, for not allowing to get to the floor. First of all, this year, not even, just basically being up front and not wasting any time because we're not going to even do one. She understands what's going on. We see it in the presidential candidates, very divided on their side of the aisle, and I get it. But still, it was the speaker who said, show us your budget and we'll show you your values. It goes on in our responsibilities. It says, in the committee, we pass a budget that it reflects our value system. And yet, we're not even going to pass a budget. And so I know, based on what I'm hearing here, there's some criticism of the president, and I'm not saying there shouldn't be, but this should be focused on the criticism of this committee, because that's what we have control of, is this committee. The budget process must be broken because we've only done it 4 times since 1974. Full appropriations process, both through the resolution process. It's very frustrating. I talked about it. I'm a business guy. There's not a person in here that, when they get into a spending problem, doesn't create a budget and say we got to live within a budget. There's no business that doesn't do that. There's no state, maybe with the exception of a couple. We all have balanced budget amendments, or programs in our states. The only place that we can continue to do this and point fingers at other people for being the problem is in Congress, the people's house. And it's a real problem that, you know, we need to get after. We keep talking about this, you know, this fix of the budget process. 8 Republican members, as described earlier, worked on this process to change it. And unfortunately, these bills will never see the light of day. I voted for the process as well. It's just really disappointing for so many of us. And I believe that if you took all the members here and you took us out in the hallway and you interviewed us individually, we'd all say, we have got to do a budget. Yet, as was described earlier, the politics doesn't allow that to happen. And the American people, quite frankly, are paying the price. That's why we have trillion-dollar deficits. Not the president's creating the trillion-dollar deficits. It's the United States Congress, us in this room. This is our job. Dr. Joyce, since taking the House, Democrats have failed to write a budget resolution. The budget resolution is the only legislative vehicle which Congress can establish a comprehensive framework for its legislative priorities and map a vision to allocate its necessary resources. Do you believe a budget, creating a budget is necessary? We'll take Congress out of it. Is necessary for anything, anyone's long-term fiscal responsibility and important to governing?
Absolutely. And I would expand by saying that I think there is a tendency, and I think this is true, this is not just true recently, there's a tendency to sort of think forward and think about the fact that, for example, the House and Senate couldn't possibly agree on a budget, so therefore one should not be done. The purpose of the Congressional Budget Act and the reason that the budget resolution was established was so the Congress had no way to articulate an overall vision for the budget. It was only dealing with the details. The budget resolution is the only place to look comprehensively at a budget and establish one, and when you don't do that, it's losing an opportunity to offer what is an alternate point of view to the point of view expressed by the president, regardless of who the president is.
So I'm going to ask you a question. I only have 48 seconds left. I'm going to skip past you because I would assume you're going to answer yes to this. So starting, and I'm sorry, I can't see all the name, Dr. Armstrong, I think, or Mr. Armstrong. Do you think the Budget Committee, you know, let's say in past 10 years, has done its job appropriately based on the responsibilities laid out here, regardless of Republican or Democrat? I'll make it easy on you.
Well, let me just say that
I've only got 23 seconds left. I'm trying to get to everybody.
GAO is not in the position to audit the Budget Committee.
I'm not asking you to audit. I'm just asking have we produced a budget for you all to be critical of the president and compare budgets?
I think that's a factual question, and I'd have to look to see how often a budget resolution has been prepared.
You've been there 42 years, and you don't know if in the last 10 years there's been a budget produced?
My focus in appropriations law is really transactional, and that's what I look for. I know that there have been
Sir, I've been here 14 months, and I can tell you there's not been a budget passed.
And, well, let me just say that I understand it is clear in the Congressional Budget Act that a budget resolution is an expectation of the act. The Congressional Budget Act, though, simply sets rules for the Congress, and the Congress can choose how to apply those.
I agree with you, and I read that, and you're right. It does not require that we produce a budget. You're right. But our responsibility as laid out by the leadership says we should produce a budget. And so that was my point in asking you that question. And my question, if I had another 10 minutes, is to ask you if this budget committee should even exist, because we're not doing the job. Thank you all.
Gentleman's time has expired. Now recognize the gentlewoman from Washington, Ms. Jayapal, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here. This has been a really interesting hearing. I think you've all articulated very well how Congress's power of purse is under threat. And I think this administration, but as we've talked about, other administrations have successfully utilized executive power and taken away some of the power that really should be with us in Congress. Certainly this administration has clearly demonstrated how that unchecked executive power can be abused, and also exposed the gaps that all of you have spoken about in law that do require congressional action to allow any executive, not just this one, but ones in the future, to truly be required to uphold that balance of powers that our founders envisioned. Some of the most egregious examples of this recent abuse of executive power have included the following. On February 14th, 2019, Congress passed the 2019 Appropriations Bill after the longest partial government shutdown in history, and the sticking point was Donald Trump's demand for $5 billion in taxpayer dollars to build a wall. Ultimately, Congress appropriated $1.3 billion, and the very next day, the president declared a national emergency to divert billions of additional dollars to pay for the wall. 7 months later, the Pentagon revealed the specific military construction projects that would lose $3.6 billion to pay for that wall. And in February of 2020, 1 year after the emergency declaration, the Pentagon announced another diversion of $3.8 billion in military funds. So, Mr. Armstrong, under current law, what requirements exist for the White House or relevant agencies to consult with Congress on the projects that are canceled to divert funds for military construction under the National Emergency Declaration, or on specific projects undertaken, or on progress of any of those projects?
The administration is required to provide Congress notice before it takes an action like that. With regard to the border wall, the administration in law has authority to transfer money, but it's tied to a notice to Congress. And when Congress gets that notice, you guys can decide what to do with it. But it's all it requires is a notice before they take the action.
And just to pick up on Representative Moulton's questions earlier, you wouldn't be able to declare a national emergency just for policy purposes, or would you?
I have never addressed that, and GAO would stay out of whether or not something is properly declared as a national emergency. When Mr. Moulton and I were talking about an administration's policy considerations, we were talking about an administration taking action that was outlawed by the Impoundment Control Act.
Yeah. The question still remains, and I understand that you wouldn't weigh in on it, but the question of what determines a national emergency, I don't know, Professor Paskoff, if you want to comment on that at all.
Oh, thank you. So I don't have the text of the provision in front of me right now, so I can't refer specifically, but I will say that there are tools that Congress could put in place using its current authorities, and also new tools that Congress could put in place. So using its current authorities, Congress could tighten these transfer restrictions. Congress could tighten the reprogramming restrictions, lowering the sums of money that are able to be moved around. Congress could could put in riders limiting very specifically saying that no sum can be spent on X. So these are all within Congress's current powers.
Yeah. And tightening the transfer restrictions, do you have more detail on what that would look like?
Sure. So throughout appropriations law, there are general provisions that say that different agencies have the ability to transfer up to certain sums of money without notice, and then without notifying Congress. And then over that amount of money, they do have to notify Congress. And similar things are true in reprogramming. So a Congress that wanted to restrict those things could simply lower the amounts that were required for notice, and could also just strongly limit the amount that's allowed for reprogramming or moving around at all, or say that it can only be done under certain very specific conditions that Congress sets, and could forbid other kinds of restrictions. Congress could, if I could just say one more thing Congress could do within its current power, is respond to actions that the executive has taken that it deems unacceptable in the next year's appropriation cycle. So,
thank you. And I only have 6 minutes, so I didn't get to the migrant protection protocols, but I just wanted to say that this implementation of it was something that Congress appropriated zero for in the February appropriations deal. And so I had some questions around that, but I'll have to save that for the next time. Thank you all very much.
Gentlewoman's time has expired. Now recognize the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
Thank you, Mr. Chairman. Thank you all for being here with us today. A little earlier, unfortunately, the majority's vice chair tends to use this forum for political purposes and as political theater. But he earlier generated a question that I'm going to pose to Mr. Armstrong. Based upon your earlier statement about breaking the law, can it then be said that a threat made by a senior member of the White House to withhold funding from a sovereign nation, or else, basically, would that also be against the law?
A threat to withhold money would not violate the Impoundment Control Act, but an actual withholding of the money would violate the act. What we found when we looked at Ukraine, and in the decision we issued in January, was that OMB had apportioned the money to withhold it, and that was clear in the apportionment schedules, and the OMB General Counsel acknowledged that in his reply to my letter. And his explanation for the withholding was not one that was acceptable by the impoundment.
And one was proven and the other wasn't, of course. Thank you for your very inequitable response. I'd like to move on to Dr. Joyce. Dr. Joyce, this congressional ceding of budget and appropriations power, when did this start? I mean, the Eisenhower administration, Kennedy, Johnson.
Well, I mean, it's a complicated answer because there was a time prior to 1980 when, for example, the failure to actually enact appropriations on time did not actually result in the threat of a government shutdown. And then there was a decision in 1980 that there had to be appropriations or agencies had no legal authority to operate. So that's when the heat really got turned up on the appropriations process. But again, as I said earlier, only 3 of the last 44 years, and that's a bipartisan problem, has the appropriations process worked the way it's supposed to. Now, in terms of the budget resolution, as I said in my testimony, the first 20 years of the Budget Act, there was a budget resolution every year. And in the last 20 years, there's only been a budget resolution about half the time. So if we're looking at the budget resolution itself, I would say it's a problem that has arisen mostly in the last 20 years.
Okay. Is it more of a legal authority, regulatory authority, or traditional authority that rings true here or untrue?
Well, I mean, there's no sanction for the failure to adopt a budget resolution, for example. So I would say that, my view on this is that the Congress, when it does not enact a budget resolution, and again, as I said earlier, there are proposals that would say we only do a budget resolution every 2 years at the beginning of the Congress. But on some kind of regular routine basis, it's my opinion that there should be a budget resolution. And when that doesn't happen, what it essentially is occurring is that the Congress is foregoing its ability to respond to the president's budget.
Some budget committees and Congresses were more successful in accomplishing a budget than others. Right. Why do you think that is?
I think there are 2 possible circumstances where it was easier to pass a budget resolution. One is in situations of unified government. When the House and Senate are controlled by the same party, we don't have this issue of one House deciding not to enact a budget resolution because it can't imagine the other House ever agreeing with it because it's supposed to be a concurrent resolution. The other is when there's something big that the Congress has decided it wants to accomplish. In 1990 and again in 1993, there were big multi-year deficit reduction packages. Those were bicameral, and they also had the agreement of both the Congress and the President. And the budget resolution was used because the reconciliation process is such an effective tool in order to make something like that happen.
You and I probably can't, I'm new to Congress, so understand this just as my constituents don't. The lack of courage of the minority to, if they're in leadership in the House, to provide a budget that perhaps would be questioned and needs to show some fortitude for what's best for the overall, rather than scoring political points. But I'm out of time, so I yield back, Mr. Chairman.
Gentleman yields back. I now recognize the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you. Thank you, Mr. Chairman. I just wanted to remind everyone of this chart that I've put up frequently. We've heard about fiscal responsibility. This chart shows that every Republican president since Nixon has ended up with a worse deficit position than they started. Every Democratic president has ended up with a better deficit position than they started off with. And this administration is well on its way to maintaining that pattern. Also, I've heard comments about proposals on the Democratic side. I would remind the Republicans that under Democratic leadership in the House, we have pay-go. So if we're going to enact one of those proposals, like Obamacare, it will be paid for. Obamacare was paid for. Unlike proposals on the other side of the aisle, like the prescriptive drug benefit, you just pass it and don't worry about it. I think if one side is going to take claim for fiscal responsibility, I think this chart shows which side it ought to be. Professor Pastakoff, you mentioned appropriations, moving money around and notifying Congress. Is that notice or permission, and exactly where does that come from?
So there's two different ways that the executive branch can move money around. One is through a transfer of money, which moves money between different appropriations. There has to be specific statutory authority for the executive branch to do a transfer.
Without that authority, it can't take place?
Without the authority, it can't take place. Reprogramming, which moves money around within a single appropriations, is generally understood to be something that the executive branch can do. That's part of what Congress allows it to do when it gives a lump sum authority, unless it makes more specific limitations on that. You asked about notice and permission. So because of a Supreme Court decision that said that one House, one committee can't be formally, can't actually give permission because that doesn't count as legislation, it's got to just be notice. It can be permission, but sort of in a loose traditional sense, not actually in a mandatory legal sense.
Suggestion was made that violations of anti-deficiency should be a criminal offense.
So in the current Anti-Deficiency Act, any officer or employee who violates certain provisions of the Anti-Deficiency Act might face administrative penalties like loss of a job or loss of some pay. Knowing and willful violations could become a criminal act.
Under present law?
Under present law. So the suggestion is that currently, it's not that people are routinely charged under those with violations, but that allows civil servants to say to political people of whatever party, I won't do that, it's against the law, I don't want to go to jail for this. So the idea is that there are no criminal penalties, there's no administrative penalties that's currently in place in the Impoundment Control Act, which leaves civil servants really at a loss for how to push back.
Yeah, Professor Chavitz, you were talking about the Anti-Deficiency Act too. Who has standing to complain? After the OLC makes a declaration, who has standing to complain?
Well, that would be sort of appropriation specific. So if there is some party that would have, or this would be under the Impoundment Control Act, if there's some party that would have received an appropriation that then doesn't receive that appropriation, they would have standing to raise that in court.
In court. Several of the committees are having challenges getting cabinet secretaries to come before their committees to defend their budget. What should the legislative reaction be to failure of a cabinet secretary to show up?
Well, I think the House in recent years under both Republican and Democratic leadership has made increasing use of the contempt of Congress mechanism. I think that is certainly available after repeated attempts to get someone to come forward. And then, one way to enforce contempt of Congress is through the power of the purse, is through saying, you know what, if you're in contempt of Congress, we're not going to pay your salary next year, or we're going to tighten your department's budget in various ways for next year, in ways that sort of really amp up the pressure.
Can you aim that sanction at a specific position?
Absolutely. You can zero out a specific salary in appropriations.
Thank you, Mr. Chairman.
Gentleman's time has expired, and now recognize the gentleman from Georgia, Mr. Woodall, for 5 minutes.
Thank you, Mr. Chairman. I was watching Mr. Scott's eyes get wide at the professor's suggestion. I don't remember his same enthusiasm during the Obama administration when we were going down that same path of zeroing out salaries, but we might not have been as close then. But the point that I'd like for you all to talk a little bit off topic is, we go back and we look at 74 in the Budget Act, we look at 76, National Emergencies Act. We were kind of united here as an Article I institution reacting against the overreaches of Article II. I've read your testimony, I've looked at all of your suggestions, but those are largely moot if we're going to continue to operate as a parliamentary institution where the president's party supports the president and you're a Republican or Democrat first and a member of the Article I second. Being willing to zero out the Trump administration salaries and not Obama administration salaries would be one of those things, and the shoe would be on both feet there. Take me back to when we had a good president from the great state of Georgia, 6 funding lapses in 4 years, but no one went without a paycheck. No government services went unmet. I know you might not be able to express an opinion, Mr. Armstrong, but the civility opinion helps us in Article I, empowers us at Article I, or diminishes us in this funding dance that happens on Capitol Hill? You mentioned it, Dr. Joyce.
I think it helps you, but it only helps you if you want it to. And what I mean by that is that it basically says that agencies cannot just continue to spend money when the Congress has not provided for that spending. But the record is not very good, as you know, of having that actually lead to more timely appropriations. And I think the focus often gets on government shutdowns, and government shutdowns are bad. But the routine practice of continuing resolutions, in my mind, is worse. And it's worse because it's more invisible what the sort of insidious, eating away at the effectiveness of the executive branch is. And there are all kinds of, GAO actually did a really good study in 2009 that really documented what the problem was. It was created by late appropriations, quite aside from whether there are shutdowns or not.
Do my two academics share that belief that it's not inherently disadvantageous to Article I and could be a positive? Professor?
If I may add, I would just say that it could be even more advantageous if you would import some of it into actual law and specify, for example, what are the executive branch can read very broadly under different administrations what constitutes the necessarily implied by law. And so the Article I could take even more power back if it would clearly specify examples that you think fall into that category and that don't.
Thank you.
I also agree, and I would point out that while shutdowns are bad, I agree that sort of taking them off the table is worse. And one thing I would point to, for example, is 2011, there was very nearly a shutdown. I think we came within about an hour or two. And that resulted in massive policy concessions across the board from Democrats who controlled both the Senate and the presidency to Republicans, right? That was an example of budget brinksmanship that created massive policy shifts. And whether or not various people agree with those policy shifts or not, it was an example of sort of successful tugging on certain powers. But I agree with Professor Pasikoff that some of the constraints need to be tightened, and in particular, in the Anti-Deficiency Act, the language that it actually uses is emergencies involving human life or property, and that then in OLC opinions becomes essential government personnel, which then becomes manipulated by presidents of both parties to cover huge swaths of the government, but then to exclude things where they want to concentrate pain. One thing I would urge Congress to do is tighten up the definition of what voluntary services can be accepted during a lapse in appropriations.
I appreciate that. And I appreciate the focus in so many of your testimonies about the Anti-Deficiency Act. We've been having administration witnesses come forward to testify on their budgets in this committee, and those folks have gotten a lot of severe tongue lashings for the ideas they've laid out there. And as my colleagues have mentioned, we've not laid out any ideas. Always easy to target folks who've laid ideas out. All of these things we complain about, we could just fix, right? The chart that Bobby Scott loves to put on the TV of presidents and who's spending what. Presidents don't spend money, right? The question is who was in control of Congress during those times, because the only person who can spend a dime is the United States Congress. So we like to target blame which brings me to the Impoundment Act and adding of the criminal penalties. I don't like putting civil servants in jail. I don't like threatening civil servants with jail, knowing and willfully the only standard that would be acceptable. Talk to me about how we have used that threat in the Anti-Deficiency Act, because I don't kicking civil servants is a sport on Capitol Hill. I don't think we need to do that, but we do need better policy outcomes.
May I answer? I see.
You may answer.
It has actually taken me a long time to come to terms with this, because my initial instinct is I too do not want to be punishing civil servants for the hard work that they do on behalf of the American people every day. Where I have eventually come to is that it acts as a deterrent. It empowers civil servants to say, I will not violate the law. And so that's the good effect that those penalties have, administrative first, and then criminal, for knowing and willful only. They allow civil servants to push back on supervisors who may be enticing them to break the law. And that kind of parallel penalty structure would empower civil servants in the same way, not punish them, but empower them to resist being forced to violate the law.
Thank you. Thank you for your indulgence, Mr. Chairman.
All right. You thought you had 10 minutes again, huh? The gentleman's time has expired. I now recognize the gentleman from California, Mr. Panetta, for 5 minutes.
Thank you, Mr. Chairman. And before I get into my opening, I just want to follow up on that, Professor Pasakoff. So you would recommend criminal penalties be in place, and you recommend it as a deterrent, it sounds like.
Right, so first, again, just to be clear, these are the same penalties that already exist in the Anti-Deficiency Act, and no one is ever criminally charged.
Okay.
Right, so just to be very clear.
And they never have been
I
in history?
think, GAO actually probably has more information about that than I do, but it is not anywhere near a common occurrence. What these penalties allow civil servants to do is say, I cannot take that action because it would violate the law.
Okay.
So those are the kinds of parallel things I'm talking about.
Understood. And what about the Impoundment Control Act? Are there any, you earlier talked about administrative criminal, which you mentioned just now. In the Impoundment Control Act, what are the penalties?
There aren't any.
Would you recommend there being the same set of penalties, starting off with administrative and starting off with the criminal? In your opinion, would you recommend that?
I would recommend that, because it would protect civil servants and allow them to do their job while following the rule of law.
And when you say criminal, so you would actually think about fines and incarceration?
I would import exactly the same structure that it currently exists in the Anti-Deficiency Act, with the recognition that it acts as a shield, not a sword.
Okay, great. Professor Pasakoff and all of you, thank you for being here. I appreciate this opportunity in which you can sort of remind us legislators, reinforce the fact that the Constitution is clear, is that we do have the power of the purse, and that it is us and not the president that should determine how our government and its programs are funded. As we've seen, presidents throughout the years have sought to gain more influence over spending. Past presidents have gone beyond simply presenting just a budget, but instead seeking to move funds for their own priorities, or choosing not to spend them at all against the wishes of this legislative body. And I think as you're hearing today, clearly, this really isn't a partisan issue. And not a partisan issue here in this this budget room, whereas Republicans and Democrats should both be willing to stand up for the authority of Congress, really no matter which party has the power of the executive branch. And so as we examine the ways to protect Congress's power of the purse, I'm glad that we're having this type of hearing, and I do hope that this session can better inform and motivate us in our legislative efforts. Now, one of the areas I think it was briefly mentioned, what I heard just for the first time, and I came in late, so I apologize, were shutdowns. Something that obviously we don't like mentioning too often, but unfortunately it does happen, as I have experienced in my just very limited time here. Professor Chaffetz, what powers and flexibilities does the executive branch have during a shutdown, and how might we want to curtail or maybe expand them if possible?
Right, so the executive power during a shutdown is determined by this language in the Anti-Deficiency Act, allowing for the acceptance of voluntary services, either when authorized by law, so in some specific statute, or when necessary to preserve human life or property. Now, that could be understood very narrowly, right? You could understand sort of necessary to preserve human life or property as being sort of limited to just some subset of the traditional law enforcement agencies or something like that. Presidents have consistently understood it, and relying on OLC opinions since the early 80s, understood it as a much broader set of civil servants. And exactly how broad is elastic. And basically, OLC has been allowed to have the last word on just how broad that category is. You can sort of sense their success in the fact that we don't even use that language in ordinary discourse. We don't talk about emergencies involving life or property. We talk about essential government personnel. That language doesn't come from statute. That comes from OLC.
Okay. All right, great. Thank you. Now, obviously, in this body, you got hundreds of members, and we have thousands of legislative issues. But unfortunately, the time when we think about spending comes just during the appropriation season or when a budget is released, it seems like. And so I would ask Professor Chaffetz, what recommendations do you have as to how we can do a better job in conducting oversight of executive spending actions?
Well, a big part of that is, I would say, is increasing congressional capacity. And as I mentioned earlier, I think the proposals adopted yesterday coming out of the Modernization Committee are a step in that direction. But if you look at the number of staff, both member staff, committee staff, and staff at organizations like GAO, CBO, CRS, it's way down from its highs in the 80s and 90s. Staff tenure is down. Staff real pay is down. Staffers are actually paid less in real dollars today than they were 2 decades ago. That really makes it much harder for Congress as an institution to do effective and continuing oversight. So my biggest piece of advice in this realm is just that Congress needs to bulk itself up. The administrative state is huge. And has been growing not only in absolute terms, but very much relative to Congress, and therefore relative to Congress's ability to keep tabs on it.
Thank you, and thanks to all of you. I yield back.
Gentleman yields back. I now recognize the gentleman from Texas, Mr. Crenshaw, for 5 minutes.
Thank you, Mr. Chairman, and thank you, everybody, for being here on this very important topic. It's been a really thoughtful discussion, and I really appreciate a lot of the interesting suggestions that everyone on the panel has offered. Oversight, to me, means a couple things. It is ensuring that we're spending the money properly, ensuring that the executive branch is executing our authorizations properly, and we've talked a lot about that. I think, on the other hand, oversight also means making sure that we are not saddling our next generation with a burdensome debt. And I want to talk about that in the latter part of my questioning here. But first, Dr. Joyce, your testimony mentions portfolio budgeting. This is one of the reforms included in the Senate's bipartisan Congressional Budget Reform Act. Can you please explain what portfolio budgeting is and how many portfolios you would envision in a budget resolution?
Well, I mean, essentially what portfolio budgeting does, and this is an idea that was first advanced by Steve Redburn, who used to work at OMB, and the late Paul Posner from George Mason University. And the idea is that, we get pretty focused on whether something is mandatory spending or discretionary spending or tax expenditures, for example. But what's essentially happening is that we have an area like housing, and there are a number of different tools that we have in the housing area, and some of them are in the tax code, and some of them are mandatory, and some of them are discretionary. And what this really does is encourages more thinking about which of those tools are most effective in a particular policy area. So the focus is on the policy area. It's not on whether something happens to be discretionary or mandatory or a tax expenditure.
Right, and that would be somewhat of a change to the process. And I mean, you mentioned earlier, though, that the problem is the operation of the process, not the process itself. Does that mean, I'm just curious, does that mean we're doomed to never pass a budget correctly, no matter what the process is? I mean, what are your thoughts on that?
Yeah, I have thought about what the incentives might be, to actually using the process as it was intended. Essentially, what has happened in the past is that the process has been used at times when the moon and the stars, sort of aligned, and people decided that they wanted to do something. I mean, what happened in 1990 that led to the, what was the Budget Enforcement Act, which is where pay-as-you-go came from, for example, was that, the two parties actually got together and they said the deficit is a problem and we want to do something about it. So it has to start there, and I think that often there is a tendency to think that there's some cute procedural trick that we can come up with to make people do things that they don't want to do. But I think that they have to want to do them first, and then the process can be used as a vehicle to make those things happen.
And I was hoping you could also expand on the wording you used in your testimony about how we need a more difficult but important kind of oversight, and what does effective oversight of the executive branch look like?
I think effective oversight of the executive branch is asking the hard questions about what it is that the Congress intended when it established this program, and is that program accomplishing what it is that the Congress wanted it to do? And that's much harder to do than the kind of oversight that I think you see too much of, which is, somebody did something wrong, or someone thinks that somebody did something wrong, and they get hauled before a committee and they get yelled at. Well, that's good theater, but it's not that helpful in terms of making sure that programs operate better.
Right, and that feeds into the suggestion we heard just a minute ago about expanding our own resources to actually identify whether a program is doing well. On the other side of oversight, I believe fundamentally is again getting a hold on the growth of our debt. And as we all know, the numbers are not in dispute. Mandatory spending is by far the biggest driver of our debt. How can we wrap that into the budget process? What would be a reasonable suggestion to make?
Well, it is wrapped into the budget process in the sense that it's the budget resolution and the reconciliation process that is the most effective tool in terms of the ability of the Congress to actually change that path. And so if you don't have a budget resolution, you don't have reconciliation. And if you don't have reconciliation, then it's very difficult to change the path of mandatory spending. I will say at the same time that that when you have a debt of this size, the answer is not whether you're going to cut mandatory spending or discretionary spending, or whether you're going to cut spending or raise taxes. The answer is all of the above. And so I think in the budget resolution, we'd have to get to a place where there are changes in mandatory spending and discretionary spending and consideration of revenue increases in order to get out of a hole the size of which we have dug ourselves.
I'm out of time, and it's of course up to the chairman, but I'd love to hear the other panelists' answers to those.
Anybody want to chime in? Well, I'll allow it. If anybody wants to comment on that. Okay. Gentleman's time is expired. Now recognize the gentleman from Nevada, Mr. Horsford, for 5 minutes.
Thank you, Mr. Chairman, and to the ranking member for holding this hearing, and to our experts. My constituents and most Americans want Congress to do its job, and I believe the budget process is one of those areas. It's one of the reasons I'm honored to be a member of this committee. My colleagues on the other side have said a number of times today and during previous hearings that the House Democrats haven't done its job. And yet on July 25th, 2019, the House passed Public Law 11637 by a vote of 284 to 149. 65 Republicans voted for that bill, including the ranking member and several members of this committee. That bill set the spending limits through 2021, and it was done in a bipartisan way with both chambers, and it was signed into law by the President of the United States. So the misleading information that continues to come out from the other side about the House not doing its job, you voted with us to set these spending limits. So let's be accurate about that with the American public. My question to the panel first is, does the Constitution give Congress the power of the purse? Yes or no to all the panelists? Quickly.
Yes. It requires expenditures to be made by law. Congress is the one that passes laws. Obviously, there's presidential participation in that process, but fundamentally, first and foremost, the responsibility rests with Congress, and first and foremost with this House because of the origination.
And that power was not given to any president, correct?
Correct.
So the core goal of the U.S. Constitution is to divide powers between all three branches of government in order to prevent any one branch from gaining dominance.
The Appropriations Clause in the Constitution states that, quote, "No money shall be drawn from the Treasury but in consequence of appropriations made by law." Mr. Chapitz, you mentioned in your statement that once the Constitution was ratified and the new national government was up and running, the earliest Congresses made clear that they understood themselves to have special responsibility for matters of the purse. Can you expound upon how the first three departments, Foreign Affairs, War, and Treasury, were set up? And I'm specifically interested in how and why Treasury was set up the way it was.
Sure. So one of the first things that the first Congress does when it assembles is creates these first three executive departments, or these first three departments. In their organic statutes, both Foreign Affairs and War are referred to as executive departments. They're created with a secretary, and the secretary is given the authority to hire a clerk, but basically no staff beyond that, and they're required to take direction from the president. The organic statute for the Treasury Department is different. It doesn't refer to it as an executive department. It creates a lot more personnel. So in addition to a secretary, it creates a treasurer, a comptroller, and several other officers. And it doesn't say anything about taking direction from the president, but it does say that it does require all kinds of reporting to Congress. Each of these different officers is given special reporting requirements to Congress. I think what we can take away from that difference in these organic statutes is that the Treasury was seen as being closer to an arm of the legislature than something like Foreign Affairs or War, which were seen as purely executive. So there's this idea that Congress had this special responsibility right from the beginning for matters of spending.
So I think that's a very important distinction and something that the structure of the separation of powers is key for all of us to understand. I want to turn finally to the Impoundment Control Act. The Congressional Budget and Impoundment Control Act of '74 responded to President Nixon's abuse of the apportionment process. The law reasserted Congress's power of the purse by prohibiting the president from apportioning funds for policy reasons and by establishing procedures to prevent the president and other governmental officials from unilaterally substituting their own funding decisions from those of Congress. Right now, the current president has made unilateral decisions to move congressionally approved funding for various military projects after the House and the Senate agreed, in a bipartisan basis, to not fully fund his request multiple times. We gave him some money to repair fencing along the border, but he wanted even more money to build an ineffective wall, which he eventually took from the Defense Department's budget. I, for one, believe this is an abuse of power. Do you have any recommendations for changes that we should make to the statutes or institutions that shape federal spending decisions? What can we do to protect the separations of powers and make sure the executive branch follows the law when it comes to spending?
May I answer this quickly? One of the big problems, in my view, with the National Emergencies Act is that when the president does declare an emergency and transfer power, Congress then has the ability to pass a resolution of disapproval. And as you know, both houses did in fact pass such a resolution, but not with veto-proof majorities. I would suggest flipping the burden. So that is to say, have a National Emergencies Act where the president can declare an emergency for a brief period of time, say 60 days, and unless Congress comes in and ratifies that within 60 days, then the emergency goes away, rather than saying that Congress has to come in and undermine the declaration of emergency. And that would I think, allow the sort of necessary flexibility for true emergencies, but prevent the abuse of the emergency power for things that really just seem like policy disagreements.
Thank you for your indulgence, Mr. Chairman. I yield.
Gentleman's time has expired. Now recognize the gentleman from Texas, Mr. Roy, for 5 minutes.
Thank the Chairman. Thank all the witnesses for taking your time, for being here and spending time with us here today. I appreciate having somebody who's a, visiting professor at the University of Texas. Proud to represent West Campus, which of course is pretty much fraternities and departments. I don't have the academic portion. I have the more fun portion of the campus. But I am delighted to have somebody here from Austin. I introduced about a year ago, I have to go back and look at the exact date, H.R. 1755, the Article 1 Act. It's a companion bill to a bill introduced by Senator Mike Lee in the United States Senate, the purpose of which is sort of reset the way we deal with national emergencies. Many of you know that there are, I think there's been 59 total emergencies since 1976 declared. 33 are still in effect. That's absurd. I mean, it's absurd that we've got emergencies that are that were declared and that are still operating and in effect since the Carter administration, I believe, if I'm correct. And so I would invite my Democrat colleagues to look at H.R. 1755. It is an effort to, again, reset the way we deal with it by essentially saying, in all cases, the president's emergency declaration would unlock emergency authorities for an interim period lasting no more than 30 days. It basically reverse where we currently it kind of continues, and if we don't act, it just keeps going. It would say it ends, and then Congress has to act, or the emergency terminates. I think that'd be a better way to go about it, right? It's the sort of inherent definition of emergency. So we'd be happy to work on a bipartisan basis to try to address that. Now, I would say that from my standpoint, the power of the purse, I'm wondering how Dr. Joyce feels about this, that if we want to exercise the power of the purse to restore the balance of power, if we think that there's a balance of power problem, whether it was under the Obama administration, if you're Republicans, vice versa, or if we're not even wearing our partisan hats and we just say, look, we just want to try to restore the balance of power between Congress and the executive branch, we always have the ability to act. And we can come together as Congress and say, don't fund that. Like fill in the blank, whatever it is. We can choose to do that if we'll go through the appropriations process and act. And just frankly, our real problem is that we don't have an appropriations and or budget process combined that has us ever sit down as a group of individuals around a table like our families or any businesses do and actually do our job. You know, my family, we all have to sit around and decide, well, I mean, our kid's gonna do this, go to this school, are we gonna have these cars, are we gonna, make these choices? Do we take a vacation this year? Do we not? Whatever it is, and we're gonna pay for this health care. And you have to make choices. But we never do, ever. We literally never make a choice. We just keep spending into oblivion. And now we're at $23.4 trillion of debt. We are at $110 million an hour. The White House and this body, no matter what I protest and vote against, which I probably will, is about to spend an ungodly amount of money in the name of stimulus that won't likely stimulate a damn thing. Not unlike the alleged stimulus from 2009 or 10. And what are we gonna do? We're gonna have, instead of a $1 trillion deficit this year, we're gonna have a $1.6789 trillion deficit. We have got to stop just going to our partisan corners and shooting at each other by saying, okay, we want defense spending, we want non-defense discretionary, what the hell, let's just raise it all, raise the caps. I respectfully disagree with the gentleman. I voted against those caps. I voted against those cap increases. Not right now, it's because of time. I appreciate it. I'd like to have the dialogue, I would. We should have a roundtable discussion on this and sit down and just roll our sleeves up and work like any American family does and figure out how to spend within our means. What are the dollars that are gonna come in the door, and then make the tough decisions that you have to do. If we do that, I would posit that Article 1 would be stronger. That Article 1 would then be put in a position of balance against Article 2. Because right now, we just throw money at the wind and we let those bureaucrats run with it no matter which party is in the White House. Dr. Joyce, I'll just leave it to you to see if you agree or disagree or have anything to say on that.
So I teach budgeting, and I've been public budgeting, and I've been doing it for a long time, and my kids say, that's a job, but it is. And so, I've studied a little bit what effective budgeting looks like, and the thing is that effective budgeting always involves compromise. And what compromise means is that nobody gets exactly what they want. And when, as you suggest, people just go to their partisan corners, and you have a group of people that are opposed to one kind of change unalterably, and another group of people that's opposed to another kind of change unalterably, all that means is that you aren't able to, to get to agreement. And so I think we have a budget that's more or less on automatic pilot, and automatic pilot is not working. And so, I don't know, because, I'm not a political scientist, and it's dangerous for me to pretend to be one, but we have this sort of disappearance of the moderates, and the moderates used to be the people that actually sort of helped make things happen.
Don't imply that I'm a moderate, or some people back home are going to get a little concerned. I'm just kidding. Thank you, Mr. Chairman.
Sure. Gentleman's time has expired. Now recognize the gentleman from Pennsylvania, Mr. Boyle, for 5 minutes.
Thank you, Mr. Chairman. And given the last exchange, let me just say thank you
to President Obama and pragmatic Republicans like Hank Paulson and Ben Bernanke, who, thank God, didn't listen to those voices who were preaching austerity and pushed through with the stimulus that helped save our economy, the worldwide economy, and lead to this historic 11-year economic expansion, the longest in American history, right up until this latest crisis with the coronavirus. And I hope that we will all learn the lessons from that history and not retreat to ideological camps. Now, Mr. Chairman, I want to applaud you for having the vision to hold a hearing like this, because too often around here, we spend 99.9% of our time dealing with the urgent issue of right now and not taking a step back to have a more thoughtful discussion process-wise about how we can improve things for the future. In my 6 years now here, probably the most asinine thing we do are these government shutdowns. So as I went to work on attempting to positively come up with a constructive solution, in my own research, I discovered that this is a relatively new phenomenon, that it's only because of a legal interpretation by the Attorney General and the Carter administration that we even have the concept of government shutdowns. I introduced legislation it's simply called the Ban Shutdown Act that would prevent all future government shutdowns. The way it would work is simply when the appropriation expires, things would continue on autopilot until there was a new appropriation. Now, I recognize the limitation in that approach. It's certainly not ideal, but in my view, it is far superior to this endless cycle of government shutdowns that actually cost us more money and have a negative effect on the economy. So I'd like to ask you what you think about that approach, and frankly, if you could suggest, if you have any suggestions on how we could end this cycle of government shutdowns. If you don't like my legislative approach, then certainly interested in hearing any and all good ideas to once and for all solve this completely needless problem. And that's open-ended to any one of you.
Well, I will say that I definitely agree with you about government shutdowns. My concern about automatic continuing resolutions is that what we could end up doing in the first place is taking away, what is what I would view to be sort of an essential, stick that can be used, which is the threat of a shutdown. And I think if we get to the place where we're just encouraging more and longer continuing resolutions, that has an effect that's not as visible, but is nonetheless harmful. So I really understand your motivation. I don't know if you've seen the bill that Senator Langford has introduced in the Senate, but he has a similar kind of bill. And the difference in that bill that I have seen is that he not only is prohibiting government shutdowns, but he's actually also doing things like prohibiting all congressional travel until an actual appropriation bills are enacted. So in my mind, you would have to couple the automatic continuing resolution with some kind of sanctions that force people to come to the table.
While at the same time not going down the sort of gimmicky road that sounds great in a populist way, but doesn't actually achieve anything.
Yeah, not doing things like just saying people aren't going to get paid.
Yeah, that's what I'm implying, yes. Professor?
So I worry about giving away too much Congress's power of the purse if you would go down that route. So respectfully, that is my concern.
Yeah.
I will say that I think a stronger mechanism might be to make it harder for the executive branch to operate during a shutdown. Not, again, to punish anybody, but when government is allowed to continue funding services and bringing in lots of people, which it did during the last shutdown, and different administrations can make different choices, it reduces incentive to compromise. And I think that what you need to end a shutdown and what you need to get to some kind of work that serves the American people is to compromise more. So I would say importing some of those restrictions that we talked about from the OLC memos into law and further tightening them so that it limits what the executive branch can do to keep a government going even when there's a shutdown.
If I could just come in really quickly on this. I think also it's worth remembering that government shutdowns are not always caused by congressional failure to pass appropriations. So the 1994 and 1995 shutdowns were passed by President Clinton vetoing appropriations bills, right? So to then sort of suggest that it's necessarily Congress's fault. The problem with an automatic CR, in my view, is that it basically massively strengthens the president's hand in any kind of bargaining with Congress, right? It says to the president, as long as you prefer the current levels of spending to whatever Congress might come up with on its own, then just refuse to work with Congress, you'll get your automatic CR and it's better. The only way to move off of the status quo on that view would be to move towards the president. That, in my view, would be a huge abdication of congressional power of the purse. And something like Senator Langford's proposal doesn't actually solve that either. It just makes it harder for Congress to stick to its guns. So this would be a massive transfer of power, I think, to the executive branch.
Gentleman's time has expired. Now recognize the gentleman from Michigan, Mr. Kildee, for 5 minutes.
Thank you, Mr. Chairman, for holding this really important hearing. Like Mr. Roy, I do share the concern about Congress reasserting its authority, and while we may occasionally travel different paths and sometimes wind up in vastly different places, when we do come to the same conclusion, even if it's from different motivations, I think we're obligated to work together. So if that possibility is open, I think we need to pursue it. So I appreciate your comments. I do think it's important that we take care to scrutinize not only the spending decisions that we make and the impact that they have on the national deficit, but the choices that we make about revenue policy and tax policy, which also have those detrimental impacts. And so we just need to be honest with ourselves about the effect that our decisions have. Obviously, Congress needs to assert its constitutional authority. The only way that our democracy survives is if we adhere to the rules set forth by our founders in the Constitution. And that means acting when a president fails to adhere to the same set of rules, no matter who that president might be. The Constitution's clear that the president can't spend money that is not appropriated by the Congress for specific purposes, and that the president must spend those dollars appropriated by Congress for the purposes that we intend. People in communities all across the country rely on that, not just because of the imperatives that the Congress think in its collective wisdom are important priorities, but because that means we are adhering to the rule of law. We are doing what the framers anticipated. Dr. Joyce, you wrote in the Washington Post that the CBO has put Congress on a more equal footing with the president and made the budget process more transparent. And as a person who long admired Alice Rivlin, and I think much of her legacy is built upon the foundational work that she did in this space to protect the independence of Congress by ensuring that the CBO played that important role. Can you maybe with that as backdrop offer some thoughts about how the CBO itself promotes a more appropriate balance of power and transparency in this process with the executive branch?
Well, I mean, thank you for having read that, and also, so this is a dangerous question to ask because I wrote an entire book about the CBO, but I will try to do it in a minute. You know, prior to the existence of CBO, the Congress had no way of systematically challenging information and numbers, really, that came out of the executive branch. And the history of CBO is a history of CBO empowering the Congress to respond to presidential proposals, both policy proposals and budget proposals. And that was true with the Carter energy policy in 1976. It was true with the Reagan budgets in the early 1980s. And so this enables the Congress to be able to effectively challenge the executive branch. It also, very importantly, gives the Congress a nonpartisan source of information on just what the effects of various policies are. Prior to the existence of CBO, if you wanted to ask how much a bill cost, then there were two sources of information for that. There was either the committee that produced the bill, which had every incentive to downplay the cost of the bill, or there was the executive branch, which miraculously thought bills that it didn't like cost a lot of money, and bills that it did like didn't cost very much money at all.
I wonder if you might comment, and this may have been covered before I arrived, it's been a busy day, on what tools you might suggest that the CBO be granted in order to more effectively deal with what we've had recent examples of. And to be fair, I'm sure there are examples that cross the span of time, but there have been more egregious examples of the administration withholding money that Congress appropriated for a specific purpose or spending money that Congress did not approve for a specific purpose. Can you talk to any of the tools that you think CBO specifically, or any other agents of government, should have in their hands to prevent that?
Well, I mean, it's really GAO that is in the position of, opining in terms of whether the administration has effectively followed the law or not, because it's GAO that gets involved in the really the budget execution process. CBO is more sort of upfront when you're making decisions on what to do. I'm hesitant to say that CBO should have any enforcement authority, because I think the whole idea of being a nonpartisan agency and then having enforcement authority is just going to get it in a lot of trouble. So CBO is about providing information, and then it's up to the Congress how it wants to use that information.
Thank you. My time's expired. I yield back.
Gentleman's time has expired, and I yield myself 10 minutes for questions. And once again, let me thank the entire panel for your testimony and your responses. It's been one of the, I think, most impressive presentations and nonpartisan presentations of a group of witnesses we've had since I've been chair. And I just want to reference one thing Mr. Roy said about how we should all sit around and talk about this. We did that in 2018. That was the Joint Select Committee, 16 of us the entire year, and virtually every question or point that's been made here about possible proposals and so forth was made then. And for one reason or another, we couldn't get 10 votes out of 16 to do it. And that was also a very, very nonpartisan process. Everybody on that group, the 8 Democrats and 8 Republicans, 4 each from the Senate and the House, was very interested in solutions and not gaining partisan advantage. And so it was a very, I think, a useful discussion. And I think virtually everyone who came out of that discussion, out of that process of almost a year's duration, said, I think as you may have said, Dr. Joyce, it wasn't the process, it's the will of the members of Congress. And that's one of the things that this is now my 12th year on the committee, and that has been very frustrating but so obvious about the budget resolution process that we've had, because it has been basically just an opportunity for scoring partisan points. The process was never really designed to be a governing process. And I think that's symptomatic of what confronts this government right now, this Congress right now, is that we don't really have a governing mentality here. We have an electoral mentality. And almost regardless of what the issue is, the strategy is, how do I get an electoral advantage on this issue, not what's the best policy for moving the country forward or solving a problem. And I don't know how we get past that, but until we do and actually begin to govern. And I think, I was a staffer here in the 70s when you had virtually the entire philosophical spectrum in both parties. And I was a staffer on the Senate side. And so you were always working across the aisle because there was always somebody who agreed with you across the aisle. And party was not nearly as significant. We've become very tribal, as everyone says, and so it's a different environment. I want to focus on one thing, though, and believe me, I have great empathy with the Republicans on the committee and in the House, because I spent 8 years in the minority. Nobody on this committee until last year has spent any time in the minority. And it's frustrating. It's frustrating. So you do things like batter the committee for not passing a budget resolution, when in fact, of course, Senator McConnell announced early this year that they were never going to bring a budget resolution to the floor in the Senate. But one of the things I'm curious about, and see if I'd leave it open to any of you, is if there are any changes you might see in the 1974 Act that would help. And that's specific, one point I would question you about is the idea that ever since we've been here, every budget resolution that's been proposed, whether it's been passed or not, was a 10-year resolution. I think the Act requires us to do 5 years. In this day and age, there's no way to write a budget for 10 years, a budget resolution that is meaningful in any respect. And both sides have played incredible games with the budget to make it look good. I remember one time when we were in the minority, the Republicans proposed a budget, and they had some $600 and something million category, and we asked them what that was, and they said, well, we just made up a number. We had to get that number, so they put the number in. And then, you know, lots of gimmicks on estimates of growth and so forth. You know, the president's budget estimates 3% growth. Right now, looks like to everyone's prediction was it would be at no more than 2. Now it looks like it's going to be 0 the rest of the year and 1% next year. That was unforeseen. So the question I have is, would that make sense to say you just have to do a budget, 1-year budget or a 2-year budget resolution, or any other changes you might see in the Budget Act that might help?
Well, if I could respond first, I think, you know, I don't remember what year it was, but there was a year in which, you know, we moved from 5 years to 10 years. And the reason, as I recall, we moved from 5 years to 10 years is because people were always doing things where the costs exploded in year 6, right?
Right.
And it's sort of more difficult to do things where the costs explode in year 11. I mean, it's so far, you know, into the future. So but I think obviously the downside of doing 10 years is that it is so hard, you know, with any kind of reliability to say what's going to happen in 10 years. I would be concerned about going much shorter than 5, only because I think you do create those incentives that if you do a 2-year resolution, then magically, you know, people are going to create programs where the costs get a lot bigger in year 3, for example.
Appreciate it. Anybody ever have a sense of that, or any other aspect of the Budget Act?
And I would just say that in terms of changes to the Budget Act itself, you know, the one that I suggested in my testimony, and I think is worth considering, is just whether there are things that we could do to make this committee more powerful. And obviously, making it more powerful, if the committee is not going to actually exercise that power, doesn't do a lot of good. But, you know, ideas like, do you want to actually, you know, put chairs and ranking members of the, you know, important money committees on this committee? Do you want to sort of, you know, strengthen the budget resolution itself, the enforcement procedures behind it, things like that?
Yeah, I was impressed by that recommendation. I'd love to have a chair a committee on government priorities. That would be a pretty interesting thing to do. One of the things that we've done this year, because we have limited jurisdiction and the budget resolution process is not working, was to actually consider this committee the oversight on the budget. So we've had hearings on various things like, and Mr. Johnson said we had a hearing on the Green New Deal. We didn't. We had a hearing on climate change and how it's going to impact how it is impacting the budget and how it might impact the budget. We're going to have a hearing later this year on artificial intelligence and how that may impact the budget. We've had an immigration reform and how that affects the budget. Again, the idea was to assemble information that might be useful to the legislating committees in those areas, committees of jurisdiction. But I think you're very right on point that this Congress has to do a better job of oversight in every respect. And I wrote an op-ed about that several years ago and said that we've had, you know, you look at the Communications Act of 1934, there's still things on the books from the 1934 Communications Act. And I mentioned when I was on the Energy and Commerce Committee, I mentioned to the chairman then that if he wanted to sponsor a bill to basically eliminate everything in the Communications Act that wasn't passed prior to 1996, which was the last prior reauthorization, I'd be happy to co-sponsor it with them because nothing can be relevant to today's world that was passed before that. So that's something that this Congress absolutely has to do. we are going to advance legislation, and I think, Mr. Roy, we're talking to you about including your recommendation in that deals with the issues we've had here. This hearing was designed to be kind of a prelude to that legislation. And a lot of the recommendations that were in your testimony are going to be a part of that, and we appreciate that. But if there were one thing that you think is the most important change we can make in order to reassert our power of the purse, what would it be? Most important recommendation?
I would say limitations. I mean, this may be fighting the question because it'll be a little bit broader than one specific thing, but limitations on the president's ability to either transfer funds, reprogram funds without some serious indication of congressional acquiescence, or refuse to spend funds that have been transferred, that is that have been appropriated. That is to say, to tighten up both the Impoundment Control Act and to, as Mr. Roy suggested, flip the burden on emergency spending and on transfer authority under that.
I think the number one important thing to do is make things more transparent. So you can't hold, you keep talking about, we've talked a lot about oversight today. It's impossible for Congress to have oversight over the executive branch if you don't know what the executive branch is doing. So I think that apportionment transparency, making the apportionments public, their final legal documents. I do not understand how in a rule of law country we can have things with the force of law that are not transparent, that are not public, and some sort of compendium, some sort of greater requirement for transparency of reprogramming and transferring actions.
Mr. Armstrong?
I agree with both of the professors here, but one thing I would add is, as has been made clear in the hearing, the Anti-Deficiency Act is the only fiscal statute which carries penalties for violation of the act. I think that the committee might want to consider imposing penalties for other fiscal statutes, like the Impoundment Control Act, but also like the Purpose Statute. I know that criminal penalties sound somewhat draconian, but Professor Pasakoff is right in that what we've seen over history is, even though the Department of Justice has never prosecuted anyone for a criminal violation of the act, it is a deterrent. And that's why GAO gets tons of requests every year for appropriations law training, because the people who actually have to execute the budget want to make sure that they're doing the right thing. And we hear in just about every class we teach, I don't look good in orange stripes, things like that. You know, and so it gets attention. And collateral to that, I think I would expand the executive officials who have a right to ask for a decision from GAO. Currently, it's heads of agencies and agency components, as well as some offices called accountable officers. But if you expand it to the budget people, you expand it to contracting officers, I think we're more likely, even if we don't get the request for decisions, and I hope it does generate into requests for decisions, but even if we don't get that, we're available for informal technical assistance, and people are more likely to reach out. And when they reach out, we're making sure that they're acting in compliance of the laws that you guys enact.
Thank you. Yes, Dr. Joyce.
So I want to say I agree with all of these. The one I would add, I would go back to something Professor Chaffetz said, which is that if you're going to do effective oversight and you're going to be a strong counterbalance to the president, you need the resources to do that. You need the staff to do that. And it is sometimes very hard politically for the Congress to spend money on itself. But when it doesn't spend money on itself and its support agencies and its staff, you know, you're really at a competitive disadvantage. And, you know, one of the reasons the Congress doesn't do better oversight is perhaps because it doesn't have incentives to do so, but also because it takes a lot of resources, a lot of staff resources in order to actually figure out what's going on in these executive agencies. And I think that would be a very important thing to do.
Right. Well, once again, my time has long expired, but I have the gavel, so. But I wanted to hear those responses, and once again, thank you for your contribution. This has been very useful, and if there's no further business, the hearing is adjourned. Oh, hold on, sorry, it's not adjourned yet. I have a housekeeping act that I neglected earlier. As a reminder, members can submit written questions to be answered later in writing. Those questions and your answers will be made part of the formal hearing record. Any members who wish to submit questions for the record may do so within 7 days. And with that, this hearing is adjourned.